The case in question is Federal Communications Commission et al. Versus Consumer Research et al. And it questions if Congress unconstitutionally delegated their power to a third party. Now, to understand the situation, we need to go back to the creation of the FCC. The Communications Act of 1934 established the Federal Communications Commission and instructed it to make available to all the people of the United States reliable communication services at reasonable charges. Look in the Constitution all you want, you will not find the power to ensure people have reliable communication services at any price. No, the General Welfare Clause does not cover it. Article 1, Section 8, Clause 1 reads, "The Congress shall have the power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States." So the General Welfare Clause only allows Congress to collect taxes, not provide services. And Congress can only collect taxes for three purposes: paying the debts, the common defense, and the general welfare of the United States, capital U, capital S, a proper noun. This law was not for the general welfare of the United States, though, but for certain people, mostly rural and the poor. The problem with this legislation goes on. The Universal Service Project arose from the concern that pure market mechanisms would leave some population segments, such as the poor and those in rural areas, without access to needed communication services. Under the 1934 Act, the FCC pursued universal service primarily through implicit subsidies, using its rate regulation authority to lower costs for some consumers at the expense of others. Congress was concerned that the market would leave some population segments without communication services, except it's not Congress's business to make sure everyone gets the services congressmen think they should. That means the Communications Act of 1934 is an unconstitutional act and therefore void. From the Supreme Court, Kate Norton v. Shelby County. An unconstitutional act is not a law. It confers no rights, it imposes no duties, it affords no protections, it creates no office. It is in legal contemplation as inoperative as though it had never been passed. Furthermore, Congress claimed to give the FCC the power to regulate telecommunication rates and to use them to subsidize communications for their special interest groups. Then in 1996, Congress upped the criminality of their act. In 1996, Congress amended the act and created a new framework for achieving universal service. Section 254 of the amended statute requires every carrier providing interstate telecommunication services to contribute to a fund known as the Universal Service Fund. Now, Congress is requiring a tax on interstate telecom providers. They may call it a contribution, but that's the same trick the mafia uses for their protection rackets. So now Congress is telling the FCC to extort money from telecommunications providers and what to use it for. Now, guess who actually pays for this alleged contribution? We the people, and our phone and internet bills. The FCC must use the money in the fund to pay for universal service subsidy programs. The statute designates the beneficiaries of universal service subsidies low-income consumers, those in rural areas, schools and libraries, and rural hospitals. So Congress tells the FCC to collect this illegal tax, then to spend it for something Congress is not authorized to spend money on. Things keep getting worse. Section 254 also sets forth principles on which the FCC shall base its universal service policies. Section 254B. Among other things, those principles direct that all consumers, including low-income consumers and those in rural areas, should have access to quality services at affordable prices. Again, providing communication services is not a power vested in the government of the United States, so Congress had no constitutional authority to write such a law. And if that weren't bad enough, the terms quality services and affordable prices are not defined. It's up to the FCC bureaucracy to do that. The FCC has appointed the Universal Service Administration Company, a private, not-for-profit corporation, as the fund's permanent administrator. As if that weren't bad enough, the FCC hires a private company to administer this extorted funding, which brings us to the case itself.